At this time, I'd like to go ahead and introduce the team for this evening. My name is Ashley Kearns. Checking everyone in and working on the tech side of things is Nicole DeRiso. Together, Nicole and I are the directors of community management for Cedar, and we oversee 8 area managers, over 60 community managers throughout the Carolinas and Tennessee. Finally, your presenter for tonight, Zach Moretz. Zach is the founding partner of Moretz Law Group, which is celebrating their 20th anniversary in business this year. Very exciting. The firm limits its practice to homeowners association law, commercial real estate, construction law, and business and corporate law. Zach has been practicing HOA law in North Carolina for 25 years. He's a board certified specialist in commercial real estate law by the North Carolina State Bar, and he's also a real estate broker himself. He grew up in Sanford, where his father was also an attorney, and he holds degrees from Oglethorpe University in Atlanta and Wake Forest School of Law. Now, little known fact, Zach was supposed to be a famous race car driver. Lucky for us, he's an expert in HOA law, and he is committed to helping HOA boards find practical solutions to their HOA problems. And he really just kind of aspires to be that type of attorney that you just might want to have a beer with, sit around and chat. So cheers, Zach. I'll turn it over to you.
Thank you, Ashley and Nicole. Appreciate all the hard work you guys did in getting this organized. These two are great, and they're like Energizer bunnies. They're always working away. So they had, in addition to manage all their other day job, they put this together. So I appreciate it. I'm honored to be here. Thank you to all of you all for all the work you do. As we know, being a director of an HOA is a well-paying, well-rewarding job. You get lots of thank yous and pats on the back. I know. So I want to say thank you to you guys for doing what you're doing, because it's not an easy job. But we can't have our HOAs and have nice places to live unless you guys do what you're doing. So round of applause to you guys for doing what you're doing and spending your evening listening to some boring attorney talk. So we'll try to keep it as less boring as we can and make it interesting. And we will welcome questions at certain intervals, and because I want it to be somewhat interactive with this many people, and with this format, it can't be totally interactive, but definitely submit your questions in the chat, and we will get to them periodically during the presentation. And then if we don't, we'll do it. We can get some more at the end, and then you're welcome to email me later, and I'll get back to you in the coming days if we didn't get to you during the presentation. I don't actually, Nicole, did we send that little handout out of the actual recorded amendment? I don't know if that got sent out or not.
Don't know, Nicole. I think we were going to put that in the chat box, and we'll work on getting that done as you speak. Go ahead.
Okay, we were going to circulate a recorded leasing amendment that we had done recently, just for everybody to see kind of what we're talking about. At the end of the day, if you're going to restrict leasing in your community, you're going to do an amendment to your restrictions to do so. What does that actually look like at the end of the day? But we can certainly send that out via email or other manner if we're having trouble sending it out right now. Okay, I'm licensed only in North Carolina. I need to make that clear. I know we have people from multiple states here, and I think a lot of HOA law is sort of common law, or it's going to be applicable to most places, at least in the Southeast. If you're dialing in from California or New York or someplace where laws are very different, you're on the wrong plane. You need to get off this plane, probably go get on another plane. But here in the Southeast, the rules are generally going to be the same. Here in North Carolina, we do have the North Carolina Planned Community Act. So that, as you may be aware, greatly restricts or controls what a North Carolina HOAs can do. You don't have that if you're in South Carolina. Tennessee, Georgia have similar but different. So now the Condominium Act is generally the same from place to place. There's small changes from state to state, but that's what we call a uniform act. So Condominium Act will actually, I can answer questions about that. Of course, only licensed in North Carolina, but if you're in a condominium, those answers are going to be more applied to you, even if you're in Tennessee or Georgia or wherever you probably are. But a lot of this is going to be somewhat North Carolina specific as far as cites to case law and things. But for the most part, I think you'll get some good quality takeaways. One thing I want to mention is kind of a pet peeve of mine and a lot of HOA attorneys is we have a lot of people refer to the governing documents of HOAs as the bylaws. Let's try to get away from that. That's not the right term. Bylaws are one part of your governing documents, right? That's the document that controls the internal operation of your HOA, how the board is elected and things like that. But that's not all your documents. The documents we're going to talk about today are your CCRs, covenants, conditions, and restrictions. If you're in a condo, it'd be typically called your condominium declaration. But that's the important document that kind of controls what you can do and especially controls what you can do as far as leasing is concerned. So let's try to use the term CCRs or governing documents, which is a more of a broader term. Let's try not to call them bylaws because that's a kind of a lesser document, but people a lot of times use it as a general term. Okay. Again, we're going to talk about leasing and HOAs, why it's a problem, if it's a problem, and how you can address the problem in your HOA in a way that's enforceable and hopefully is supported by the members of your HOA. The first thing I want to bring up is leasing really a problem? And if so, why is it a problem? I know we have an epidemic right now of these large companies buying up houses whenever they can find them to turn into rentals. It seems like it's maybe slowed down a little bit in the last month or two with inflation going up. But regardless of inflation, we live in a very attractive part of the country or part of the world, really. People are going to be flowing in to this area to live for the next 20 years. So leasing is something we're going to have to deal with in our HOAs, regardless of what the interest rates are. Does everyone agree that leasing is a problem in HOAs? I think most people do. In fact, we have an authority as strong as the Federal Department of Housing and Urban Development, which specifically states in its guidance documents that it restricts leasing in condominiums. HUD does not control single-family homes, single-family neighborhoods, has nothing to do with what your restrictions can say, but it does for condominiums. It's taken the position that for FHA loans to be issued for condominiums, it has to approve the condominium documents, and it will not approve them if it doesn't like the leasing restrictions, but it actually is in favor of leasing restrictions. So this is one of the few government authorities you're going to get that actually gives you a reason to support putting leasing restrictions in your community. The HUD documents say it is FHA. HUD is the greater department. FHA is a department underneath housing and urban development within the federal government. It is FHA's position that owner occupants serve to stabilize the financial viability of the projects and are less likely to default on their obligations to ownership associations than non-owner occupants. Owner occupants, unlike either investors or renters, are incentivized to cooperate with other unit owners to ensure successful operation of the project. Analysis of FHA's insured condominium portfolio indicates that condominium loans have a lower default rate than other FHA programs, which FHA attributes in part to its project-wide owner occupancy requirements. So they require 50% in most cases of condominiums to be owner occupied. So if somebody's questioning you, why is this important? Well, you have the number one authority in the federal government giving you support of restricting leasing in your community. So what problems does leasing lead to? Well, if there are too many leases, it can reduce your property values in your neighborhood. Nobody wants that, right? Even if it's a home is leased and kept up well, those leases can bring down the property values in the overall community if there are too many of them. Next, of course, it's a problem if tenants don't behave, right? We all have probably encountered traffic issues, parking, noise, sort of the revolving door effect of tenants checking in and out, especially in condominiums or townhomes. That's a problem because the moving of furniture and things in and out causes damage. So I don't think there's any question that those are real effects. Also, in some communities that may be a gated community or where you have fobs for the pool or where you're maybe closer knit, for example, condos or townhomes, could present a security problem because you're having to give out codes or things to people that aren't actually people that live there. And then some communities feel like it reduces the exclusiveness of their community if people can rent. So those are some of the issues that lead people to want to reduce leasing in their neighborhoods. I do want to keep in mind, and for us to all remember, that there are ways to address most of the problems that tenants can cause without prohibiting leasing, right? We can fine the owner if their tenants are not cooperating or abiding by the rules. We can suspend their privileges, to use the pool or the clubhouse or other amenities that you might have, your docks or piers. You can also suspend the right to vote at elections. And if worse comes to worst, we can get an injunction from a court prohibiting, behaviors that are nuisance behaviors. In fact, we are filing one tomorrow in a condominium client of ours where there was a unit that was rented to some a series of bad tenants, and someone was actually murdered in the unit. So obviously that's the last thing you ever want to have happen. And we're going to get a court order to try to prevent that unit from ever being leased again, because that landlord doesn't keep an eye on his tenants at all. So you don't necessarily have to go straight to prohibiting or limiting leasing if those are the problems. Parking, traffic, people should be being disciplined, whether they are the owner or a tenant or not. If they're taking up too much space on the road or parking on the lawns, nobody should do that regardless of whether they're a tenant or an owner or not keeping the place up. So just don't forget that you do have those duties, and regardless of who's in the home, you need to fulfill your duties to keep up the covenants and the restrictions. Occasionally we get the question, do HOAs really have the legal authority to restrict leasing? Yes, that is very clear. Again, sometimes folks, and I tend to be a libertarian, people ought to in general be able to do what they want to do with their property, but it's very clear that leasing affects the entire community and it's something that your HOA has the right to limit. There's even a North Carolina court case, which is called McElveen-Hunter versus Fountain Manor Association, where the North Carolina Court of Appeals specifically stated that the HOA did have the right to restrict leasing by amending its documents. And furthermore, this question comes up sometimes as well. A leasing restriction or any other amendment that you might properly pass to your governing documents of your association takes effect immediately. So as soon as it is recorded, any restriction on the use of land has to be recorded at the Register of Deeds. But once it's recorded, it takes effect. And so sometimes people ask, well, isn't everybody that lives in the community now grandfathered, and this restriction will only apply to people that purchase in my community after we record it? No, it applies as of the day you record it. And if you say leasing is prohibited or limited, then after that day, it's limited, after that day that it's recorded. Now, most governing documents, CCRs that we deal with, do not have leasing restrictions in them originally. If you think about it, if you're a developer dumping a lot of money into some land to build out a bunch of lots or build a condominium building, you want to make it as easy as possible to sell those houses or those condos. You're probably not going to go out of your way to lease, restrict leasing yourself. You might want to sell those units to investors. So typically, if you're going to restrict leasing in your community, you're going to have to adopt an amendment to your governing documents. If you learn nothing else from this webinar, learn this. I'm going to give you a quote from a North Carolina Court of Appeals case called Wine 2 LLC versus Porter from 2009. But this same language is in case after case after case having to do with HOAs and restrictive covenants. The law looks with disfavor upon covenants restricting the free use of property. As a consequence, the law declares that nothing can be read into a restrictive covenant, enlarging its meaning beyond what its language plainly and unmistakably imports. So that is a foundational principle of dealing with HOA law and recorded restrictions. The courts, and especially in the southern states, are going to always lean toward protecting a homeowner's property rights. And so if there's vagueness in a restriction, they're gonna find in favor of the homeowner, in favor of the property owner. So this is why these restrictions have to be recorded, and they've got to be drawn very precisely and specifically, and a lot of thought needs to go into any restriction that you're going to put, but especially a leasing restriction, because you're limiting people's ability to make money off of their property. So it's very important to understand that limitation of judges in North Carolina and the other southern states, that we are trained from day one of law school that restrictions are narrowly construed, and the benefit of the doubt is always going to go to the homeowner. So if a restriction is properly drafted and clear, then it's going to be enforced by a court. But if there's vagueness, the homeowner is going to get the benefit of the doubt. And a great example of that, a little bit off topic, but there was a Charlotte case a few years ago where, as most of your restrictions probably contain prohibitions on having livestock on your lot or in your home, right? And many of you may be aware of the case where the homeowners had two dwarf Nigerian goats, which they claimed were pets. Their names were Ernie and Bert. And the association told them, hey, get those goats out of here. That's livestock. Restrictions clearly prohibit livestock. Well, they went all the way up to the Court of Appeals, and the Court of Appeals said, well, livestock is a vague term. Really? I mean, that's what the court said. It gave the homeowners the benefit of the doubt. The homeowners claimed they were pets. The court said livestock could be interpreted multiple ways. If they say they're pets, we're going to give them the benefit of the doubt. They get to keep Ernie and Bert. So that's just an example for you of how the homeowner or the property owner is going to get the benefit of the doubt unless a restriction is very carefully drafted. And yes, we should put that in our restrictions. No leasing to pets. Thank you for the comment. Okay, we're going to talk about the amendment process a little later in the discussion, but I want you to be very understanding of that concept because it's very important as most anything you do on your HOA board. Briefly, I'm going to take questions here in just a second, but I want to hit a couple other topics before we do that. What constitutes a lease, right? If we're going to prohibit leasing, we need to define in our amendment that we're going to record or vote on what we mean by a lease, right? I think the term lease is pretty clear. A lease is just a right to use property that is not your own property. So if someone is using the property that is not the owner, that's a lease. Sounds simple. No rent has to exchange hands, but you may wonder if, for example, letting someone use your home for a while you're out of town and they're visiting, or a house sitter, or a corporate apartment that's owned by a company and it lets its employees stay there when they're in town. These are different things you can start thinking about and see, well, maybe the term lease is not that clear. But in general, we're going to define it as anyone living there who's not the owner. If you want to, and that's the next topic on this, what is defined as a tenant? If you want to, as your board or your community, when you're considering a leasing amendment, say, well, we're going to let people's kids live there. If someone owns the home, but their child goes to UNC Charlotte, and they want to buy a home, condo for the kid to live in while they're at UNC Charlotte. Well, that's fine. That's a family member. The kid is not actually the owner, but their parents are the owner. We're going to call that an exception to leasing, or grandparents, or parents. But that's up to you when you're discussing your leasing amendment. You could certainly argue that just because it's my son, I have 3 sons and a daughter. A couple of them would be good caretakers of my home. A couple of them, I'm not so sure I'd want them in my home without direct supervision. So certainly they can be considered tenants because they are not the owners. But that's up to you to decide how you're going to define the term tenant when you consider your leasing restriction. You can define it as limited as you want to, or provide some exceptions for family members, things like that. Okay, why don't we stop right now, Ashley and Nicole, and take a few questions if there's any pertinent ones, or if I said anything intelligent.
Absolutely. We do have a couple of good questions. I've tried to answer some of them as they're coming through in the chat. But one, what if a homeowner sells to an investor without notifying the HOA or the board or the management company or whatever, and they're selling it to American Homes for Rent without checking with anyone first? What are the ramifications? What can be done at that point?
Right. And I think, we can, this is a good point to talk about enforcement. We can do that. Enforcement is not the easiest thing with leasing restrictions. So we're going to talk about how to implement a leasing restriction, but then you have to enforce it, right? And people are going to try to evade it. We had one condominium owner who was white, and they had a black person living there that they claimed was their cousin. They may have been cousins, but it seemed a little unlikely. You're going to have people try to evade it. So I think the first thing that you want to keep in mind when you implement a leasing restriction is it may not be possible to achieve 100% compliance. You need to, aim for 95% compliance, realize that some people are going to try to evade it. But I mean, you do have the different enforcement mechanisms that we mentioned earlier when something like that happens. Remember, when we do a leasing amendment, it's going to be recorded in the register of deeds. It's not effective till it's recorded. But once it is recorded, once a document is recorded, it is considered notice to all the world. Literally, you don't have to actually have notice of it or ever go read it, but you legally, that American Home for Rent is considered that they know about it. So if they buy it and don't realize there's leasing restrictions, that's their fault and they can't lease it. It doesn't matter whether they really knew about it or not. They should have done a proper title search, which sometimes I wonder if they even do. They're buying things in a week, Yeah. But the enforcement is, something you just have to stay on top of. You may have to get your attorney involved, send a letter. I know we sent one of those, I think today, to, I don't know if it was American Homes for Rent, but one of those.
That was just an example, but yeah.
Hey, so
that actually answers one of the next questions. Was once the restrictions are passed and recorded, what can you do to enforce those who have already had tenants in place before those passed? And I think what you're saying is once they're passed, there would be no additional signing of a new lease, but maybe their tenant can stay until the lease is up. And then how does that work?
And again, grandfathering. So I think that's something we're going to hit a little later. Let's wait until we get to the amendment process, but you're going to need to grandfather those that are currently leased. I know I said earlier that once it's recorded, it takes effect, right? It's legally enforceable. However, those are the people that are potentially going to sue you if you tell them they have to kick their tenant out.
Right.
Because they live in Wisconsin and they're using that tenant, their rent to pay their mortgage. Well, you're asking for a lawsuit there. So in all practicality, you're going to have to let those that are already rented be grandfathered until either the property changes hands or at least it becomes vacant.
Right.
Otherwise, you're asking for a lawsuit.
Okay, so there was another question I'm not sure I quite understand, so I will let Ms. Kim turn her mic on to maybe clarify. How do you deal with landlords who live in another state or city year round or season long? I know she's in a coastal town, and a lot of those are, second homes, and they rent those out, whether it's short term or long term. How do you deal with the landlords that may not be aware of the state laws? I think maybe that's what she's asking.
Right. Were we going to let her chime in, or
Yeah,
is that right? Kim?
Ms. Kim, that was your question.
Okay. I think, am I on now?
Yes,
Can you hear
ma'am.
me?
Yes,
Okay.
ma'am.
Yes, I'm down in Charleston, and we have issues where we have several owners who basically are not present. They live in DC, Pennsylvania, whatever, and they do short-term weekly rentals. When those people are constantly causing problems and there is no supervision through either the rental management company or if they self-rent, what exactly is our recourse to enforce proper behavior, following of rules, I guess it would be?
Yeah, I mean, you're going to want to do a leasing, restriction that, and this is the big thing, probably many of you are thinking, short-term rentals. That's a big problem, at least in places where you are. Myrtle Beach, Wilmington, Charleston, where people want to go visit. Maybe not so much Charlotte, Lake Norman. So we want to definitely get a leasing restriction recorded that prohibits short-term leasing, I would think. And then, again, enforcement is always going to be a problem. You can enforce against the tenants as well as the owner, but we're going to have to, have some strong communication with the owner and, fine them and let those fines start stacking up until they decide to behave. Getting a court order is something that's available, but that is expensive and time consuming. So enforcement is always going to be, again, you're going to try to achieve 90% a lot of times, especially in your situation, when you're in a resort or vacation type area.
Thanks.
Yeah, absolutely. So we had another question, and I'm just catching up because as soon as you said we're opening for questions, a bunch came through. So bear with me. Can we set a limit of how many homes are being leased in a community? And I believe that you alluded to that in your restrictions.
Yes, and again, at the later in the discussion, we're going to talk about the amendment process and what provisions you would probably want to include in your amendment. And I was going to speak of that there. We recommend that you have a leasing cap. Maybe we tend to try to push HOAs away from prohibiting it altogether, although there's nothing that says you can't prohibit altogether, but we don't think it's the best practice. So a 10%, 15% cap, we think is a good idea in most places. And then you have to maintain a waiting list.
Yeah. So Ms. Karen, stay tuned. You're going to get more information on that. Best practices around mixed developments where you have some single family and some townhomes, but both are members of an HOA. So you've got a master and a townhome or a courtyard. Is there a best practice for setting regulations for those? Is that something that you might be touching on later as well?
Well, I didn't really have that specifically in my outline, so we can certainly try to hit that real quick. Okay. I mean, certainly you can record different restrictions based on different property types, such as townhome restrictions could be different than the single family restrictions. Although
membership types.
You would have to have your vote, your 67% vote or whatever it is separately for those. But I guess was the question where we were talking mixed use, like there might be commercial as well, or just single family and townhome. Typically, we would just do, restriction that would say, no more than 10% of either of them, for example, could be leased.
I will let Mr. Michael open his microphone to specify, but it reads as if it's just a master and a townhome sort of situation where you have mixed home types, not commercial
Right.
versus residential.
Normally, we would say, 10% of either one, something like that.
Okay, and there are different membership types in those governing documents that would say which membership type could have what type of leasing or what percentage. Is that correct? Typically?
Typically, some may not. I've certainly seen plenty that don't differentiate when they really ought to. Certainly in North Carolina, the law certainly allows restrictions to be, different restrictions to apply to different neighborhoods is the term that we use. So you can certainly do it that way, but you don't have to.
Okay, so I'm going to try to answer some of these in the chat as we go along, because a lot of
Okay.
these may be
Okay.
slightly redundant, maybe a little duplication, but I think you're going to touch on some of these as we go forward. So
Okay,
we'll go ahead and
let's move on then. I will say, I think one thing, a little trend maybe in the questions or something is that you can pretty much, your documents can pretty much say whatever you want them to say.
Yep.
They can't discriminate. Obviously, they can't be contrary to public policy, whatever that may be. But in general, if you can get an amendment passed, that, generally 67% in North Carolina, that 67% of folks are in favor of, you can do whatever you want in your documents for the most part. So there is not a great deal of law that limits specifically what can be in your restrictions, what kind of limitations you can have. And I should say there's very little that talks about leasing at all, certainly in North Carolina and South Carolina. So generally it's wide open. There's nothing that says you can't prohibit leasing altogether or, do whatever you want. Our best practices may shy away from prohibiting altogether, but just be aware, if you can get an amendment passed, it's generally going to be enforceable. So don't think that you're limited in what you can do.
Right.
All right, let's move on and talk about short-term rentals a little bit. I know that's a hot topic for a lot of folks.
thank you.
A question we get, first of all, short-term rental, just make sure we're all talking about the same thing, is an Airbnb, VRBO, these type of thing, where typically it's 30 days or less is considered a short-term rental. Most HOAs that we deal with, that we help do leasing amendments, want to prohibit those altogether. And you can certainly do that. There's nothing that says you can't. We usually just put it flat out in there that rentals of the short-term rentals of the kind commonly marketed by Airbnb, VRBO of less than X days or weeks are hereby specifically prohibited. So we also state that it is prohibited to advertise any unit on any of those sites. And we also say that it is prohibited to, if we're going to prohibit leasing altogether, you can't list a property for lease, and you can't even put a for lease sign in the yard. So again, all these things we can do, and typically do, especially for the short-term rentals. We get the question, sometimes I've told you all that you're probably going to all have to adopt amendments to your restrictions if you don't already have leasing restrictions. We get the question fairly often, well, isn't that a business use? Somebody that's renting it week by week or weekend by weekend, that's really a business. That's not a residential use. And our documents specifically say all homes or condo units or townhomes are limited only to residential use only. And that's clearly a business, therefore it's prohibited, right? No, incorrect. Remember that quote from the case I read you earlier? That any vagueness is going to be interpreted against the HOA or against enforcing the restriction, well, there you go again. The courts, at least in North Carolina, have stated that they basically reiterated that restrictions are going to be narrowly construed. A negative covenant prohibiting business and commercial use of the property does not bar short-term residential vacation rentals. The trial court did not err in granting defendant's motion for summary judgment and denying plaintiff's motion for summary judgment. So in that case, not only did the HOA lose in trying to argue that the homeowner couldn't do short-term vacation rentals because it was quote unquote a business, but they lost on summary judgment, which if you know anything about litigation, summary judgment means you had no case. The court basically threw it out. So it didn't even go to a trial or anything. So you're not going to be able to rest on that limitation, which is in most restrictions, no business use. That's not going to help you. You're going to have to have an amendment. When we talk about amending your documents or adding restrictions, in North Carolina, this is not the case in South Carolina. North Carolina Court of Appeals has adopted a rule that all amendments to governing documents must be reasonable. They did that in 2006 in the case Armstrong versus Ledges. And prior to 2006, that case came as a shock to all of us HOA attorneys. As I told you earlier, generally your restrictions are going to be enforced. If you adopt an amendment, court's going to enforce them as long as it's not contrary to public policy or discriminatory and it was adopted in the proper manner. Well, all of a sudden this case kind of came out of nowhere, and it's the North Carolina Supreme Court, so it is the top court, the law of the land in North Carolina, that all amendments to recorded restrictions have to be reasonable to be enforceable. What does that mean? I don't know what that means. There have been about 5 cases since then. The law develops very slowly, where the reasonableness was argued one way or the other. Most of those cases had to do with assessments. In the case, the Armstrong versus Ledges case, that was a little mountain community that didn't have any assessments at all. And some new people came in and wanted to spiff the place up and add, specifically they wanted to add a little entry monument and landscaping and add lights. And so they got an amendment passed adding a restriction, adding assessments where previously there was no assessments at all. And the Armstrongs took them to court and said, Your Honor, we bought in here knowing there were no assessments. We didn't want to live in a place that charged assessments, and they've changed it. They've changed the basic character of the community. And the Supreme Court said, we agree. You're right. Can't do that. All amendments must be reasonable. All right, whatever. So now we got to deal with that. So if you're in Myrtle Beach or maybe Charleston, possibly limiting short-term rentals might not be reasonable in your particular situation. If there have been lots of short-term rentals going on, you're in a condo tower in Myrtle Beach where half of them have been rented for years, you'd be on a little bit of a shaky ground there as to the reasonableness. Now, in your typical sort of large lot, single family, older subdivision, I don't think you're going to have to worry about really a reasonableness argument if you don't have a lot of rentals already in your community. But that's something we have to think about anytime an amendment is proposed, whether it's a leasing amendment or any other type of amendment. And we kind of have to have a little CYA as attorneys with the client and say, hey, we told you. I don't know if somebody's going to come out of the woodwork and sue you 6 months after we record this amendment. It's highly unlikely. Again, there have been, I think, 5 cases that have gone up to the Court of Appeals or the Supreme Court since 2006 in North Carolina. So it's unlikely, but it is something you got to be aware of if you're in sort of a resort area or association where you already have a lot of rentals. Okay, let's take a quick break here for a second and get any questions on short-term rentals.
Okay, I had a lot of questions about the ability to, or what you can do if you're not meeting quorum, if you're not getting the votes, or if if the board is allowed to pass these without a vote. All of these are dependent upon the governing documents. Those are very specific questions, and I would have to review the governing documents to know the answer to a lot of those.
Yeah, I can address that briefly, actually. I would say,
Please.
there, you do see some restrictions that say, it might say, the board can pass reasonable rules and regulations limiting leasing. I would be concerned on that one. If there's just no way you can get an amendment passed, okay. And the general rule is your board can adopt reasonable rules and regulations governing your association, and they are generally enforceable. The North Carolina Plan and Community Act, for example, says that explicitly. I remember in South Carolina, you don't have a Plan and Community Act, so you're just purely going by what your actual
Right.
documents themselves say.
Wild, Wild West down here.
Yep, that's what we call it, Wild Wild West. Anyway, maybe you have some language in there that does suggest that you can limit leasing. Unless it's pretty strong language, I would be not real comfortable using just rules and regulations to limit leasing, because it is restricting the use of land. It's not just using the common area. Well, the HOA owns the common area, right? It can control how it gets used. Parking is something that's shared. Streets are things that are shared. How we interact as neighbors in a townhome, we're directly next door to each other, right? Those are things that are reasonable to control. But leasing is something that directly gets to the very root of how I can use my property. And limiting that really needs to be pretty explicit to be enforceable, at least to survive a legal challenge. You know, you can always take the risk that you won't face a legal challenge, but you'd be much better off getting a very specific recorded
Absolutely.
restriction.
So what would be the best practice in a community that right now it's not a problem, but they want to make sure that it never becomes a problem? So is that to just go ahead and pass the resolution now and get it on the books?
We're still referring to the situation where they have some authority in their documents and they want to pass some rules and regulations
I think this was Mr. Joel. He said best practice to prevent that happening. And I think we were talking about short-term rentals at the time. He says at this moment, it's not a problem, but so get ahead of it, go ahead and pass a resolution on short-term rentals, leasing restrictions, whether it's, 6 months to a year, going ahead and getting ahead of that. Is that probably the best advice? Or
I think if you have, if your documents provide you some ability to pass rules and regulations, they give you some authority in your documents to do rules and regulations limiting leasing, then go ahead and do it while you work on the amendment. I think that'd be the best thing. But if you get somebody that hires an attorney and tries to challenge it, you need to realize that you're probably going to be a loser.
Then we have another question from Ms. Kim again. She's down in Charleston. What about putting a moratorium on new buyers that they cannot short-term rental? Our neighboring community has done that. Can you restrict the use of common areas to short-term rentals, the pool or the dock, and let owners rent, but renters can't use the pool or dock? And I think in this particular situation, there was actually this neighborhood, there was actually a rule against tenants using the grills as well. I think that was a long time ago, but can you restrict what tenants can do versus what owners can do?
There's no authority on that I'm aware of from a court or anything. I think it's, I don't think it's right, personally. If you're going to allow leasing, if someone is legally leasing this unit, then that unit has with it, and if you look at your documents, it says each owner has an easement and right to use all the common areas. And typically it says it's assignable to your guests and invitees and family. I think there are other ways of going about it than treating people as second-class citizens. So I think if it got into a dispute, there would be support in your documents that the language that I just quoted, that would be in the tenant's favor. And I think, if you don't want to have tenants or leasing, you need to address it head on rather than sort of treating those folks as second-class citizens. Although when you get into docks and piers, that is a different, there's liability there. And I think anybody that uses those should have to have an insurance policy, and they should have to name the HOA as an additional insured and show the HOA that they have insurance, because there's, I've seen boats sink and they try to blame the HOA, and certainly people can get hurt or drown, or get caught between the dock and the boat, all kinds of things. So that's one where you might argue that there is a reasonable basis for limiting use of that to only the owners, especially if they have a dock, they have a boat there. Well, you can have two boats. So I can see limitations on the usage of docks or piers when you have like dedicated slips and things like that with boats in them. But otherwise, generally, I think that's a tough one. There is a court case in, I want to say maybe it's Wisconsin, Midwest, somewhere where they said the HOA is not required to subsidize this owner's use of his property as an Airbnb and let people to use the pool week by week by week. That kind of makes sense as well. But I'd rather us limit short-term leasing rather than allow someone to lease, but then tell folks they can't use the pool. It's hard enough to get people to, when people that are actual owners that haven't paid the dues and you tell them they can't use the pool, it's going to be real hard for people you don't even know who they are.
Right. And so going back to that first part of that question, setting a moratorium on new owners for short-term rentals, that's the way to get ahead of it, is to just kind of go ahead and record a document that says a lease must be 6 months or longer, or something to that effect. And then future owners who buy into the property would have to adhere to that. Is that correct?
Yeah, you broke up a little bit, but I think
I'm sorry.
I typically would not use the word moratorium, but I mean,
right.
Once you pass a leasing restriction and we write it up for you and you sign it, and then we go record it at the Register of Deeds, it applies. So I think at that point, you could say no more short-term rentals after that date. Again, though, if someone has purchased that unit for that specific reason, it's called an investment-backed expectation. Courts typically will enforce people's investment-backed expectation. They spent $400,000 buying that unit to use as an Airbnb. They've been using it for 2 years. That's the person that's going to sue you. So I'm not saying it's not enforceable at the date you record it, but at least in North Carolina, you have this reasonableness requirement. And I wouldn't be surprised to see other states adopt some similar thing. If you hit them with that case, for example, a court could very likely go, well, we don't think that's reasonable in that case. Just putting a hard stop on the ones that are ongoing going to be difficult, but certainly it would apply to any new owners for sure.
Okay, and this is a tiny bit off topic, but this is in regards to reaching quorum at a meeting, and it came up in the chat that the percentage of quorum, and I know this is the case in North Carolina for most associations, it does not apply to South Carolina as far as I know, that the percentage of quorum decreases as you adjourn to a new date by sometimes 50%, 25% or whatever. Can you speak to that before we move on to the next subject?
Sure. That is becoming a more and more common provision and restrictions, and the revisions to the North Carolina Nonprofit Corporations Act that were related to COVID response provided that the quorum does by law have for membership meetings if the quorum is not obtained, which I disagree with. I think that's poor. I've got some 2-unit, 4-unit HOAs believe it or not, condos, sometimes you'll set up a condo to be able to do a duplex in a place where a duplex isn't legally allowed, but they can't prohibit a 2-unit condo. Well, I got 2 people on my board. Like, I really don't want to half the quorum requirement there. 2 is too small for quorum requirement, but 1's definitely too small. But that, statute says the 2 of them call a meeting and one of them doesn't show up, one that did show up can reconvene it tomorrow and do whatever you want. That doesn't make much sense. But you have to keep in mind, though, to adopt amendments to your restrictions is typically going to take 67% or some amount that's larger than your quorum anyway. So you're going to have to get 67% to show up regardless, at least in North Carolina. In South Carolina, It's whatever your documents say, but typically it's going to be at least 51%. If not, I mean, I've seen them to 90%. So the quorum is not really your biggest problem here. It's getting enough people to vote in favor of the amendment.
Right. Okay.
Let's move on. Unless there was any questions that were jumping out at you, Ashley?
No, we're approaching about 7:20. So let's go ahead and move forward with the material.
Yeah. So our last section to discuss is the actual amendment process. So I want to go through a little bit of how you go about amending them. So remember, we've talked about rules and regulations and things, and maybe you have a leasing restriction that's kind of vague in your current documents or whatever. The vast majority of cases, you're going to need to amend your documents to adopt a leasing restriction. And I wanted to pass out a leasing restriction that we had recorded recently, but I could probably share my screen and show the one that we were handing out.
We did share it in the chat. I'll share it one more time, just so that it's down the line.
People can download it from there, or
they should be able to click on this attachment as a PDF and open that. But feel free to share your screen. That would be helpful for those who can't get to the chat.
Okay, let's just do that real quick so they can just see a general idea of it. And I'm trying to think. Okay, let's see. Share screen. This one over here. All right. Can folks see that document there?
If you could zoom in, I think it might be helpful.
Okay, let's try that. Whoa.
That's
really
much better.
Okay.
Yeah.
Are you getting nods or thumbs up at least? Okay.
Well, everybody's camera's off, but I can see it.
Right. Okay. All right. This is a leasing amendment that we recorded, I guess, in June of last year for HOA in Charlotte. And, it's a public document, so I don't think I'm betraying anything. But this would typically be what a leasing restriction that we would prepare would look like. And so if you, I'm just going to kind of scroll through it here. But the first thing I want to point out is it doesn't just say, hey, leasing is prohibited in Harrington Woods. Thank you. See you later. This thing is 3-4 pages long. Right? So it's 4 pages substantively. And then you got the signatures, right? So there's a lot of stuff to think about when you do one of these amendments that you might not immediately think about. Again, we hit on a little bit about defining what do we mean by a lease? What do we mean by a tenant? You can see in this particular one, they did a 15% cap. There were already a good bit of tenants in this community already to begin with. Interestingly, this is the first little subdivision I lived in when we first moved to Charlotte back in 2000. So they contacted me a couple of years ago, and I was like, I'm familiar with Harrington Woods. I used to live there. But you see, we kind of go into a pretty good amount of detail on what is meant by a lease. Here, the paragraph 3 talks about what's a lease and what isn't. They have an exception there for children, parents, or grandparents. Here's sort of a grandfathering provision in this paragraph 4 that goes into a good bit of detail about if your grandfather, when the grandfather expires, if it hasn't been leased for a period of 4 months or more, we're going to say, okay, that's no longer a rental. The next person gets to have that's on the waiting list gets to go. You can't just leave yours empty and take up a space on the waiting list. So anytime you have to do this 15% or some cap, right, there's always going to be a waiting list. So then you got to figure out how do you manage that waiting list. We talk about the process of getting approval. If you want to rent yours, you got to submit your lease, and you have a certain amount of time. Once we say, yes, there's room on the waiting list, or the board says, you can rent it. Well, you got to rent it within 90 days, or then we're going to move on to the next person. Here's the stuff that we require the tenant to provide. Or I'm sorry, the landlord, a copy of the lease. Personal information can be redacted. We want contact information for the landlord, because if they're in New York or whatever, we still need to know how to get to them. And information for who the tenant is as well, because we don't want it to be a revolving door. You may want, especially in a townhome or condos, you probably want the license tags or make and model of their cars. Here we have restrictions on the short-term lease and the signage. If you're going to restrict leasing, then we don't want to have any rent signs in the yards either. This next paragraph, we get into, again, sort of what constitutes a lease. What if you just rent out a room in your house? So we go into some detail on time sharing and renting out a room, things like that. Finally, well, I guess it's not finally, but another thing to consider is in this paragraph 9, we have a hardship exception, which I think is something, again, I try to be a practical guy, somebody you might want to have a beer with. It could be you, a board member. You were all into limiting leasing at the time, but then your employer said, hey, I need you to go to Seattle for a year and help get this new plant set up. Well, hell, now you might want to lease your place, right? If you're going to be gone for a year, unless your company is going to handle it, or you get a sabbatical, or you need to go take care of your sick mother, out of town. You might need to be able to make your mortgage payment while you're gone. So this provides for sort of a hardship exception. Even if you are prohibited from leasing, you can come to the board, and provided it's a limited exception, we may allow you to have it for a limited time period. Then we get into enforcement and try to give as much rights as we can to the board to enforce the restrictions, fining $100 a day. If the owner is behind in their assessments, we say that the HOA can demand the tenant pay the rent to the HOA, which you can imagine would probably get your assessments caught up pretty quick if they would do that. We say down here that the HOA can evict any tenant which is occupying a home in violation of the leasing restriction. I have no idea if that's enforceable. I doubt that a judge is going to let you do that. When you go to eviction court, you present the lease. Well, HOA is not going to have a lease with this person. But hey, we put it in here, and at least it gives us something to hang our hat on if we need to. So I just wanted to give you an idea of what a leasing restriction, once it's recorded, looks like, and it takes 4 pages. So if your documents have a couple sentences in there that refer to restricting leasing, it's probably not enough. Talking about the process, remember all amendments have to be reasonable. So it's kind of a facts and circumstances test, depending on if you're a big single family lot subdivision that has no leasing currently. Don Heiser, I see you here. Or if you're like Kim, that you're in, I don't know if it's condos or what, in South of Broad in Charleston, where you got a lot of leasing going on already, you're going to have to, that's going to determine what your document said.
She's Folly Beach.
I'm sorry?
Folly Beach.
Oh, Folly Beach. Or somebody
Way south of Broad.
Yeah. Okay, sorry. You were calling Greater Charleston. Do we have that slide for the HUD? I told you HUD. The HUD tells you what they deem as reasonable restrictions, and I don't know if we pop that slide up or not, but and this only applies to condos. Only applies to condos, but I wouldn't be surprised if you don't find states starting to weigh in on these leasing restrictions. And eventually somebody's going to go to court and say, hey, this is not fair that they won't let me lease my unit. What is a court going to look at as far as reasonableness in that situation that comes up? They might look at federal Department of Housing and Urban Development's rules as to what they think is reasonable. It'd be the slide number 3. That was the first thing I read from HUD. The third slide was the one I'm referring to now, or third and fourth. HUD says, hey, in a condominium association, we will allow you to restrict the total number or percentage of units that can be leased. You can restrict the minimum and maximum lease terms. Hey, that's great. You can prohibit transient leasing, less than 30 days. So they are saying you can prohibit short-term rentals. You can require a specific lease term. You can require the association to be provided a copy of the lease. You can require the names of the tenants. You require the lease to be in writing. You can require that the lease says that the tenant has to comply with the terms and conditions of the CCRs. You can even require that the rent be paid to the association if the owner is delinquent. That's pretty liberal, really. I think that's kind of nice. And then HUD also lists things that they won't allow a condominium association to limit as far as leasing. And remember, this is if that condo association wants people in the association to be able to get FHA-backed mortgages, right? I mean, if you don't care about that, if you're in South Park and you're, $800,000 condo, maybe if FHA-backed mortgages are not a concern to you or to your board. But you can't, HUD says you can't prohibit leasing altogether in an FHA-backed or in a condo that has FHA-backed loans. You can't require the owner to occupy the unit for a certain amount of time before they can lease it. Well, we do that all the time in our leasing restrictions. You can't require the board to approve the actual tenant themselves, which is a bad idea anyway. You can't require a potential tenant to meet with the board first. That would be potentially discriminatory. So anyway, that gives you some example of what at least the federal government thinks are reasonable versus unreasonable restrictions. As I said earlier, we would suggest rental caps as far as a percentage or a number if you're a smaller HOA rather than just prohibiting leasing altogether. Basically for the couple of the reasons I mentioned, that HUD doesn't agree that you should do that. And B, it could be you. I don't think it hurts most associations to have a couple of rentals. It's actually one of the precepts of good urban design is to have a mix of housing types. But that doesn't mean you got to let it get out of hand. A lot of HOAs want to require that the home first be lived in. That is the number one way to keep these large corporate American Homes for Rent, et cetera, from buying into your neighborhood. Again, HUD says they don't want it done in an FHA-backed condominium complex, but that doesn't apply to single family or townhomes or any condos that don't care about FHA insured loans. So generally, we're doing that for all our HOAs. The one I just shared with you, the amendment had that. It said, I think they had to live there for a year first or 2 years first. I think that's a good idea. Remember, when you're doing your restriction, we can't get into the identity of the tenant. That's not your business, and you're going to get sued for discrimination if you get into meeting with the tenants or looking at their credit. You cannot do that. You can't even discriminate on familial status, which is how people come together, how many kids they have, how they want to define themselves as a family, even how many people they want to have in the home. You cannot discriminate against that. And then finally, we do recommend grandfathering existing rentals. Those are going to be your biggest opponents that could challenge your amendment legally. B, you might need their votes. 67% or up or even down can be hard to achieve. You know how dealing with apathy in HOAs can be. You might need a couple of votes from those people. If you tell them, look, vote in favor of this, it's not going to apply to you. As long as you own that unit, you can lease it, assuming it's currently leased now. It's only going to apply when you sell the unit. You might be able to get them to vote for you in that case. And finally, you know, those are members of your community who have spent money buying that home to rent it out. Potentially, you do have to treat them fairly. And that's the court. You don't want to be the test case that goes to court. And you've got to keep it reasonable if you want to stay out of court. Finally, just try to bring it to a conclusion here. The amendment process is typically, we tell people to gauge the temperature of the community first. I know we were talking to Joanne or Eric are on the call today about that. Let's gauge the temperature of the community first before you send out an amendment to be voted on. You might get some feedback that's negative, or it might help you adjust what you're doing. So I like to have a community meeting, barbecue, pizza night, whatever first, kind of get some idea. Then you send out a notice and ballot. Pretty much everything is going to electronic voting, or at least sending out a ballot, which has to be signed, voted, and returned in some manner. It can be returned electronically, can be dropped off at a box at the clubhouse, drop it off at president's house. Want to make it easy on people. People get enough junk mail, and a lot of them don't want to be involved with the HOA anyway, and just make it as easy as possible. I know we have some where they will send it out in an envelope with a self-addressed stamped envelope, a stamped card, postcard. Yes or no, it's already stamped, it's already addressed, just drop it in any mailbox. But these days you can do it electronically too. You can vote by email for that matter, as long as you know that it's valid. When you're voting via ballot rather than at a meeting, which people seem to not want to come to meetings anymore after COVID, it has to have a deadline in North Carolina. The ballot has to have a deadline by which it has to be returned. So we help our clients prepare that notice and ballot. They get it out, maybe give 30 days to get your 67% or whatever back. We say, you let us know when it's done. We'll prepare this document for you, like the one I just showed you. You sign it, we'll get it recorded. You may want to have a meeting there somewhere in the middle to gauge everybody's temperature, you know, before, maybe a week or two before you have to have the deadline, so you can see how it's going. You get some feedback that it's not going well, you may have to go beat the bushes. You may get enough back before the deadline that you know you can rock and roll. But you want to, I think communication and transparency are your number one rule as a board member with an HOA. So
Zach, while you're on that topic,
transport.
I'm sorry to interrupt. We did have a question about electronic voting versus a written ballot, whether mailed in or emailed in.
Okay.
I know that something passed in North Carolina during the 2020 COVID thing, did not happen in South Carolina. I'm not certain that it happened in Tennessee either, but could you speak to the electronic voting versus in person versus and written ballot?
Yeah, and it pretty much liberalized voting and meetings to be held electronically. There was never necessarily a restriction on voting electronically, but there was a requirement that you had to have at least an in-person annual meeting every year. Well, that in-person requirement was removed in North Carolina. So that meeting can be totally electronic as long as it's like we're doing now. Both parties have the opportunity to be heard and communicate in a two-way manner. That is considered official, effective annual meeting or special meeting if you need to have a meeting as far as to vote on an amendment or something. It's hard to vote in the way that we're meeting right now, right? Everybody could put their hands up, but you have to, if somebody's going to go through and count all the little hands and little boxes, the voting really needs to be in some other manner. There is software that's available. Ashley and Nicole can maybe speak more on that, but a vote can be as easy as an email, as long as the association has a reasonable basis for believing that the vote is truly from who it says it's from, and the vote is very clear, you know, yes, no, and it has their email signature, it's the email address that's regularly used by this person, you can accept that vote. And you can do the same with proxies. I can send you an email, say, I hereby appoint Ashley Kearns as my proxy. She can vote for me on this topic. That's sufficient. The only thing that you can't do is send out notices of meetings or votes solely electronically unless the HOA has a good email address from every single member and has confirmed that with every single member. So you're still going to have to send out, unfortunately, your meeting and vote notices like you're doing this amendment via mail and electronically. There's no way you're going to have, unlikely you're going to have 100% valid email addresses. But other than that, it's greatly liberalized it, and pretty much that's how most things are moving toward these days, which is a relief. It makes things a lot easier.
Yeah.
We can go to the final questions and answers. I breezed through the amendment process kind of quickly there, but I think most people have a general idea of how to do an amendment. And it definitely takes some politicking sometimes, especially if your requirement is more than 67%.
Yes.
As you may know, but I hope look at that amendment that we passed out or that was available in the comments or the chat, and it gives you an idea of the things you need to be thinking about there.
Absolutely.
Any other questions?
And we did miss several questions. I have an email address here on your screen for questions that did not get answered tonight. I think we touched on most of them. Some of them were very specific, and a lot of them, the answer is it just depends on your documents. Every document is different on what your voting requirements are,
Yep.
what your quorum is, what your board's powers
You gotta
are.
read those documents for sure, especially in South Carolina or when you don't have the Planned Community Act. Here we have, it can save you in North Carolina in a few situations if your documents are vague or.
Exactly.
But some South Carolina can be hit or miss. And by the way,
So
there's a typo on that email address. You see, it's Moretz, not Moretz.
Oh, yeah, you're right.
Moretz, not T-E-Z. But you.
Yeah, that'll go to undeliverable for sure. We'll fix that. It's zac@moretzlaw.com. So send any of your questions there. Zach, I did have one question that actually came up several times.
Yes.
And it was in relation to restricting pets for tenants when an owner is completely permitted to have their own dog or cat or multiple pets. Is there a difference in what you can allow tenants to have in a property, or does that just depend on what the owner's lease says?
So the question would be, can you limit a tenant's right to bring pets with them as opposed versus the owner's the right?
Correct. If there are no rules for the owners in pet, whether weight requirement or number of pets,
Right.
but you want to make sure that tenants are limited
Right.
to what kind of pets they can have.
Well, you can certainly put that in your leasing amendment if you're going to do one. Certainly, I don't see any reason not to do that. I try to caution HOA boards about getting involved in the pet situation. I found that people will fight over their pet to their last penny. I mean, you can tow their car away before they'll let you take their poodle. So I literally had somebody just fight. I mean, we went to court back and forth, but they had too many pets or I don't even remember what it was, too large a pet. So people they will fight you over their pets. So be careful with that. But you could do that in your leasing amendment. And I will point out, if you're going to do an amendment, some people say, well, heck, if we're going to go to all this trouble, send out a ballot, why don't we put some other things on there too? If we want to add pet restrictions or parking or, things like that, you'll just find that if you hit people with too much, their eyes will roll back in their heads and they'll lose interest. And the leasing amendment is pretty important because it really goes to the value of the homes in the community. So you want that leasing amendment to get passed, but you could, if you have people are interested in other issues, you can certainly, while you're doing an amendment, maybe you include other things in there. Again, Don Heiser didn't go well in his community, but sometimes it does, just depending on your particular community, but that is an opportunity to get some other things in there as well. And staying on the pet topic, in our restrictions, a lot of times now we're saying if there are pet issues, call animal control. Because I don't want any of my HOAs it says no pit bulls in the document, and somebody had a pit bull and you didn't know about it and it attacked someone. Is the HOA going to get sued for not having enforced that pit bull restriction? Possibly. I'd rather it not be in there at all. You know what I mean? If you think about it, if you put it in there, don't you have some duty to enforce it? And you don't, and then somebody gets hurt. That concerns me. I'd rather have law enforcement deal with pets if I could, but in condos, obviously, you have a little bit different situation because you're in such close quarters.
Absolutely. Well, Zach, I want to thank you for your time. I will note that the slide has been updated to the correct address and just switch that. Okay, so